I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Department of Justice has just filed with the Supreme Court of the United States its opposition to Donald Trump's application to vacate the order of the 11th Circuit, granting the Department of Motion's partial stay, which returned to the Department of Justice the 100 classified records that the Department of Justice obtained during the valid search warrant executed at Mar-A-Lago on August 8th. You will recall that on September 5th, Judge Aileen Canon, the very inexperienced judge who was appointed by Trump in 2020, who was assigned this case that Donald Trump filed called a motion for judicial oversight. On September 5th, Judge Aileen Canon asserted equitable jurisdiction. She said, I don't care that there is a magistrate judge who signed the search warrant and found probable cause. I, Judge Aileen Canon, I am going to intervene here and assert that I have jurisdiction over this case. And I am ordering you, the Department of Justice, to stop your criminal investigation into Donald Trump that utilizes any of the records you obtained during the search warrant executed at Mar-A-Lago on August 8th. The Department of Justice was like, what? What are you talking about, Judge Aileen Canon? That's not the law. You can't assert equitable jurisdiction. Look, we are going to appeal your entire assertion of equitable jurisdiction, and we're going to do it on an expedited basis. But even if we appeal your assertion of equitable jurisdiction on an expedited basis, it's going to take some time. In fact, based on some recent orders by the 11th Circuit, which granted the motion to expedite the appeal, it's going to still take until mid-November, late November, until there's oral arguments. So what did the Department of Justice do? They went to the 11th Circuit and said, look, Judge Aileen Canon was completely wrong in her order asserting equitable jurisdiction and starting this special master process and saying that we can't utilize our documents in connection with our own criminal investigation with our own documents. But what's damaging us most now, what's causing us irreparable harm, we need our classified records back. And there could be no argument whatsoever that Donald Trump can claim any possessory ownership in classified records that belong to the United States government. So are you claiming that, Donald Trump? So that's what the Department of Justice argued to the 11th Circuit. And the 11th Circuit was like, yeah, you're right, Department of Justice. And Donald Trump, in his arguments to the 11th Circuit, never even claimed that he had a possessory ownership in these records. He just said, maybe I have them, maybe I don't know. Let's just let the special master decide. And so on September 21, the 11th Circuit heard argument from the Department of Justice to grant a partial stay just regarding the 100 classified records pending the overall appeal by the Department of Justice regarding the 11,000 other documents they obtained during the August 8th search warrant. The 11th Circuit granted the motion filed by the Department of Justice and said, you should have your 100 classified records back. Here you go. Here are your classified records back. And that should not be part of the special master process at all. Take your documents back. The special master can just deal with the other 11,000 records. Then, recently, on October 4th, Donald Trump filed an application that was an application to partially vacate what the 11th Circuit did. Now, here's what Donald Trump asked the Supreme Court to do and what he is asking the Supreme Court to do. He's not challenging that the Department of Justice can get their classified records back. But here's the insidious thing that Donald Trump is asking. He's asking the Supreme Court to allow those classified records to go back as well into the special master process so that they could be disseminated to Donald Trump. You see, Donald Trump's argument, his sole argument to the Supreme Court to vacate or essentially partially overrule or stop what the 11th Circuit did is Donald Trump argued the 11th Circuit has no appellate jurisdiction to intervene and interfere with Judge Aileen Canon's order regarding the special master process. That is not within the appellate appellate review procedures of types of cases the 11th Circuit can hear. And the 11th Circuit addressed those frivolous arguments when those were raised to the 11th Circuit. And the 11th Circuit said, first off, we have what's called pendant jurisdiction. These issues are all inextricably intertwined. The injunction by Judge Aileen Canon stopping the Department of Justice from utilizing their 100 classified records is intertwined. It's inextricably intertwined. It's related, in other words, to the special master order, and we can have pendant jurisdiction over the special master order. The 11th Circuit also argued, in any event, we don't need to exert pendant jurisdiction, which is one of the forms of appellate jurisdiction that allows us to make rulings. The 11th Circuit also argued, look, what Judge Aileen Canon did was an injunction. The special master aspect, where the special master gets documents, is all part of the injunctive relief at issue, and that is something that we're allowed to decide on. One of the things that we have jurisdiction on are injunctions, and that injunctive relief is injunctive relief that would stop the Department of Justice for doing something. So, of course, we as the 11th Circuit can get involved. And one of the other arguments that the Department of Justice made to the 11th Circuit, and which the 11th Circuit also found, is that the 11th Circuit could exercise jurisdiction as what's called a collateral order. And they have jurisdiction over collateral orders. And a collateral order is basically an order that would allow, that would foreclose future ability of the Department of Justice to do something. Here would foreclose the Department of Justice to have the opportunity to engage in their criminal investigation, because Donald Trump will have now seen the classified records that would be returned to him by the special master, if that's what Donald Trump is asking for. In any event, the 11th Circuit said, of course, we have appellate jurisdiction. And so Donald Trump argued to the Supreme Court, 11th Circuit should not have had jurisdiction, but Donald Trump didn't argue any of the other factors. And this is something that the Department of Justice pointed out right away in their opposition that they just filed with the Supreme Court. So I want to read from you just what they said right away. So one of the first things that the Department of Justice says in their application, they go, this application concerns an unprecedented order by the district court restricting the executive branch's use of its own highly classified records in an ongoing criminal investigation and directing the dissemination of those records outside the executive branch for special master review. Just think about that framing right there. And they're talking about Judge Aileen Canon's order, an unprecedented order by Canon restricting the executive branch from using our own highly classified records in connection with our ongoing criminal investigation and ordering us to give those documents to someone else. That has never happened before. And then the Department of Justice goes over the different standards that the Supreme Court would have to apply here if the Supreme Court was going to grant Donald Trump's application to vacate what the 11th Circuit is doing. And here are the standards. Number one, the case very likely would be reviewed by the Supreme Court upon final disposition in the Court of Appeals. Two, the Court of Appeals is demonstrably wrong in its application of accepted standards in deciding to issue the stay. And three, applicants' rights may be seriously and irreparably injured by the stay. And here, in its opposition, the Department of Justice states, Donald Trump did not even address two of those factors when Donald Trump filed with the Supreme Court. All Donald Trump focused on was this idea that the 11th Circuit should not have had appellate jurisdiction. But Donald Trump did not make any argument, Supreme Court, about that first factor and about that third factor. And so the first factor, the case very likely would be reviewed by the Supreme Court upon final disposition in the Court of Appeals. That refers to, would the Supreme Court, after the Court of Appeals made a final ruling regarding the case, would the Supreme Court grant certiorari or full oral argument before the Supreme Court? The Supreme Court rejects like 97% of the cases or something like that that are petitioned on cert before it. And this case is not a novel issue of law. It is a well-settled issue of law that the executive branch should not have their classified records stolen from them by people like Donald Trump. And by the way, Trump doesn't even address this factor, the Department of Justice says. The next factor that they say the Department of Justice doesn't even address is factor 3. Applicants' rights may be seriously and irreparably injured by the stay. And the Department of Justice argues, why would Donald Trump's rights be irreparably injured by the 11th Circuit panel? Mind you, the 11th Circuit panel that made that ruling granting the motion for partial stay, which gave the Department of Justice the 100 classified records back, 2 Trump justices, 1 Obama justice, they reached a per curiam decision, meaning that it was an opinion reached unanimously by all 3 of the judges who all said the Department of Justice should have their records back. And here the Department of Justice is saying, what injury? They're not your records. What irreparable harm would be caused if you don't get the records through the special master showing you the records? What irreparable harm is this? In fact, what the Department of Justice argues, if you factor in the other equitable factors, the Department of Justice, we are the ones who would suffer irreparable harm if we have to show you classified records that are subject of an ongoing criminal investigation. Our criminal investigation, our national security interests would be compromised. We can't unring the bell. So in fact, we're the ones who would be irreparably harmed, not you, not the criminal, not the person who stole the records. You wouldn't be irreparably harmed. And then they say Donald Trump doesn't even address it. And what they point out again is Trump has never claimed that he owns these classified records. He's never made the claim to Judge Aileen Canon. He's never made the claim to the 11th Circuit. And he's not making the claim here that he has a possessory ownership over our government records, especially our classified records, nor could he make that claim. So of course he couldn't make an argument that there was irreparable harm, nor has he made filings to suggest that argument. And then they address, though, the issue of the appellate jurisdiction of the 11th Circuit, because that's the only issue that Donald Trump actually addresses in his petition to vacate. And their argument, frankly, follows the same arguments that I gave you earlier in this video about the 11th Circuit and what the 11th Circuit argued. The 11th Circuit said we have pendant jurisdiction. So you're learning the legal terms. What's a pendant jurisdiction? You know it now. Pendant jurisdiction is a type of appellate jurisdiction where issues are inextricably intertwined. And here the 11th Circuit said, well, we clearly have jurisdiction over injunctive reliefs. Judge Aileen Cannon's order was an injunction. It stopped the Department of Justice. It enjoined them from utilizing their own records in a criminal investigation. That's what an injunction is. And doing that in the context of a special master process, it is inextricably intertwined with the underlying injunction. Those are related things. Then the 11th Circuit said, and here the Department of Justice argues, it doesn't matter because we don't need pendant jurisdiction. What Judge Aileen Cannon did, let's not give her the benefit of the doubt because she was sloppy in her order and she didn't require what normally has to be filed when parties seek injunctions like affidavits under penalty of perjury. She just let Trump's lawyers say, whatevs, we need our records back, whatever, give us our records back. When you file an injunction, you have to make a showing. You have to submit affidavits from the parties, from the moving parties, seeking the documents back or seeking the court to get a party to do something or not do something. You need a declaration. Judge Aileen Cannon did none of that. But nonetheless, the Department of Justice is arguing here, and the 11th Circuit's already said this, that what Judge Aileen Cannon ordered was an injunction. The special master portion of her order, that there's the special master process, is part of the injunction enjoining the Department of Justice from not utilizing their records. And so the 11th Circuit said, of course we have appellate jurisdiction to make an order here. And also the final thing that the Department of Justice argues here, and what the 11th Circuit has also already basically held, is that the directive to divulge classified documents potentially to the special master and back to Trump, is what would be a collateral order, and collateral orders are reviewable on appeals. And so this is just to break down the definition for you. An interlocutory ruling, and what an interlocutory ruling means is a ruling before a final disposition of the case. This is an emergency order to return the classified records back. So that was an interlocutory review that the Department of Justice sought and was granted by the 11th Circuit. And so here the Department of Justice says an interlocutory ruling is immediately appealable as a collateral order if it is, quote, conclusive, comma, resolves important questions separate from the merits, comma, and is effectively unreviewable on appeal from the final judgment in the underlying action. And here, the Department of Justice, as I said earlier, states the district court's order compelling the disclosure of documents bearing classification markings in the special master proceedings during the pendency of an ongoing investigation satisfies those criteria because it conclusively determines the government's obligation to disclose those sensitive materials to Donald Trump. And that once those documents, those sensitive materials that would harm our national security interest are shown to Donald Trump, there ain't no unringing that bell. Donald Trump will have seen it. The criminal investigation will be compromised, and our national security interest could be severely harmed, and frankly, has already been harmed. And so those were the factors there as well that the Department of Justice analyzed, why there was appellate jurisdiction. And then the Department of Justice went on to say as well, the Court of Appeals did not clearly and demonstrably err in determining that the government was likely to succeed on the merits. And notice that standard. The standard that Trump would have to show is that the 11th Circuit, 2 Trump appointees, 1 Obama appointee, clearly and demonstrably erred. And as the Department of Justice says here, they didn't err. Yet alone could you show that they clearly and demonstrably erred. Yet alone did Trump even argue that. Trump never made that argument. He just made that argument of no appellate jurisdiction because of this far-fetched, weird legal theory that somehow the special master process is its own entity, that Judge Aileen Canon, a district court, can wave a magic wand and say, special master, you do whatever you want. It's not appealable. I, the district court, can do whatever. 11th Circuit, you don't have jurisdiction. I can do whatever I want as Judge Aileen Canon. But here's one of the ultimate ironies of this too, and why this is such a gaslighting thing that Trump did in filing this for the Supreme Court. Because the special master has already said at hearings, why should I look at these classified records? And Judge Aileen Canon has overruled the special master's recommendations at each and every turn where the special master has said, look, Donald Trump should file affidavits under penalty of perjury, stating that the evidence log is actually a true and verifiable evidence log, so he's not out there lying about it and saying that these documents were planted. Donald Trump should have to go on a regular basis, on a rolling basis, and start making the categories about what documents are what with respect to the 11,000 records. Judge Aileen Cannon's like, nah, let's just wait till the end of it. The special master says, I think that there needs to be some briefing on whether the special master, and Judge Aileen Cannon can even hear at the end of this process about return of property. Shouldn't that go to the magistrate judge originally? Shouldn't that go to Judge Reinhardt, that Judge Aileen Cannon usurped authority from when she asserted equitable jurisdiction that she shouldn't have had? And then Judge Aileen Cannon's like, nope, I got this. I asserted equitable jurisdiction. I don't want to hear no briefing on whether the magistrate should hear it. I'm the one who's going to be in charge. So the ultimate irony here is Trump is asking the Supreme Court to only partially vacate the order on the motion for partial stay, that basically says, look, Department of Justice, you can go through your criminal investigation with these records. I can't appeal that, but I want those documents to also go to the special master. So the special master shows me the records, and the special master's already said, I don't want to show you these records. These records are classified records, because Trump is trying to rely on Judge Aileen Canon to overturn what the special master is saying if those records go to the special master. That's the other aspect, the other layer of bad faith here. But while this process is taking place, and one thing I should mention about this process too. So this motion practice actually, unfortunately, goes before Judge Clarence Thomas. Each of the Supreme Court justices are assigned like a supervisory role to make emergency orders using that criteria that I discussed earlier in this video. And Justice Clarence Thomas had previously been assigned the 11th Circuit. And so Justice Clarence Thomas can make those rulings, can make the emergency order. It would then have to follow those standards that I told you. Then it would be revisable by the entire court if he somehow made the outlandish ruling that there should be a partial vacate of the 11th Circuit's order, and that should go back to the special master. That would then likely go before the entire Supreme Court. And I do not think, even with this Supreme Court, there would ever be the votes there to allow what Trump is asking for, because this is a Supreme Court with one of their ideologies being the unitary executive. And here you're claiming that a private citizen now can steal top secret classified records, obstruct, and the executive branch would be impaired and interfered with and can't conduct criminal investigations. It would upend the entire executive branch. And this Supreme Court, setting aside these issues, have always held this unitary executive doctrine on issues that were close calls. And this is not even a close call. The executive branch should not have their classified records being stolen from them. So the next step here that we wait for is Clarence Thomas can either make the ruling himself, he can refer a decision to the entire court. If he makes the ruling himself, it could then be revisable by the court if he somehow makes the wrong ruling here. And if he refers it to the court, the full court can make a ruling. What do I think is going to happen, even with Clarence Thomas being Clarence Thomas, even with the Supreme Court being the Supreme Court? I still remain confident that Trump's arguments are so legally flawed. He didn't even address two of the three standards for the Supreme Court to possibly even grant a application to vacate what the 11th Circuit did. He didn't address the irreparable harm standard, and he didn't address the first standard as well. So he didn't address standards 1 and 3. So the fact that he didn't address those standards and just addressed the appellate jurisdiction, I don't think that Clarence Thomas is going to do it. I don't think the full Supreme Court will grant the relief at issue, but we will see what happens next. Separately, the Department of Justice had filed a motion to expedite the appeal, of Judge Aileen Cannon asserting jurisdiction in the first place, right? So this issue before the Supreme Court, this deals with that narrow issue of the 100 classified records that the Department of Justice got back, because that's why it was an emergency. The Department of Justice went to the 11th Circuit. We need these documents. Our national security is on the line. The 11th Circuit granted it, and now Trump's saying, Trump's saying, I don't care about your national security. I don't care about that. Mine. Give it to the special master. I want those classified records. That's what Trump's doing there. Separately, Department of Justice saying Judge Aileen Cannon should never have intervened. She didn't have jurisdiction in the first place. And she asserted what's called equitable jurisdiction, meaning that there's no other like actual grounds in statutes or in laws that say she should have jurisdiction. But she found these extraordinary factors, which the 11th Circuit held with respect to the classified records, that she was wrong on each factor. And the Department of Justice said, look, you found that she shouldn't have jurisdiction for the classified records. Same analysis for the other 11,000 records at issue. She should never have asserted jurisdiction. The 11th Circuit's granted an expedited briefing schedule there. That briefing will be completed in mid-November to late November. And as I've said, I expect the 11th Circuit to make a ruling late November, early December, stating that Judge Aileen Canon should never have had jurisdiction in the first place. The Department of Justice will be filing their opening brief on October 14th to the 11th Circuit. Wow. It's a pretty good legal analysis, pretty long legal analysis there. But those are all of the facts. I appreciate you staying with me here. Very important that you understand all of the dynamics at issue here. Make sure you hit the subscribe button right now. We are on our way to 1 million subscribers. Thanks to you. Hit the subscribe button right now. In addition, one way you can help grow this independent media platform is by joining us on Patreon, patreon.com/MeidasTouch, patreon.com/MeidasTouch. Become a patron today. There is a number of exclusive benefit packages. You could become a producer of the MeidasTouch podcast, an honorary producer. Your name will appear. How cool is that? Behind the scenes footage of me and my brothers, who are also the co-founders of MeidasTouch. You can get postcards from us, other backstage, behind the scenes stuff, and more. Patreon.com/MeidasTouch. I am Ben Meiselas from the MeidasTouch Network. Thank you so much for being a part of the Meidas Mighty.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.